Okay, this is the October 17, 2019 meeting of the Fire and Police Commission. Present are Commissioners Commissioner Solar, Crowther, McKenzie, Cocroft, and myself, Commissioner DeVocas. Also in attendance is our Executive Director, Griselda Aldretti. We have one item on the executive agenda, which will remain an open session item. We will proceed with the Robert's Rules of Order training.
Thank you, Mr. Chairman and members. Jim Owczarski, City Clerk. It is always a pleasure to be with you. Your executive director approached me, and we actually had a number of conversations about how, how we could get this sort of training for you. And I volunteered along the way that on occasion, I've been asked to do these. And she said, "Well, could you do one for us?" And I said, "I would love to." I admit I love talking about parliamentary practice, probably more than most people, probably more than you do. So I will be brief and try to, but I am always happy to answer questions as we go. So I'll just jump into it. I call it the experience of parliamentary practice because I want to make clear what this presentation is not. There are a lot of great classes you can take. In fact, I've taken them. That's how you become a parliamentarian on Robert's Rules of Order that go into great detail, and that's not what this is. But let me start, I guess, at the beginning, which is by way of biography and what am I doing here? And that sort of explains, but this actually bears on the way I do this presentation. And the reason is because I really came at this from two ways. My degrees are actually in history and in journalism. I was going to be a history professor once upon a time, and I pursued that. Journalism paid the bill along the way. And both those things led me to working for a number of years, if you've ever been down at the Bristol Renaissance Fair. That's back when I had hair and a better attitude about comedy. And that too, however, wasn't paying the bills. And so eventually I knew I wanted to start a family, and that allows me to put up a gratuitous picture of my son. And that, because of all that, allowed me to say that I worked my way up and into being a journalist, and I watched it from the outside. And I watched the way bodies just like yours used Robert's Rules of Order in parliamentary practice, and I took down a lot of notes over the years. But then I also came in and I did this job. I became an analyst for the city of Milwaukee in 1999. I became council records manager in 2004, deputy city clerk in 2007, and I've been city clerk since 2012. And in that role, and as deputy, I am the parliamentarian for the city of Milwaukee's Common Council. So that's sort of my route to getting here. And that led me to have a long conversation with people all over the city. What drives our quest for parliamentary rules? The number one thing, I think, is a desire, like it says even in the rules, a desire for order, if not courtesy. I say this front and center every time I give this presentation. I get called a lot, actually, to say, we have this body where everybody hates each other, everybody's accusing each other of things. Can you please come in and show us how Robert's Rules of Order can make our lives better? And I have to tell them every time, it won't. It will not. It will not restore issues of trust and basic decency. It can, however, provide order, if not courtesy. And it is that desire for order that I think fundamentally drives people's desire to see parliamentary practice and rules of order. It's also a desire for fair play, to make sure that everybody is heard, whether that be a chairman or woman, any member, and the public, to make sure that each are treated equitably and in a way that everybody understands. And finally, the protection of the majority and the minority. We speak a lot and justly, and I'm not here speaking, of course, of racial or ethnic or sexual minorities. I'm speaking of the minorities in terms of voting bodies. We always speak of the need to protect the rights of minorities, as well we should. But there's also a lot in Roberts that talks about how you protect the rights of the minority, or of the majority, from the efforts of the minority to gum up the works and to prevent progress from going forward. So I think all those things drive what we're doing. But to me, the whole of what we're doing here today is summed up in this quote that's actually at the prologue from the man who wrote the book, Henry Roberts, where there is no law, but every man does what is right in his own eyes, there is the least of real liberty. And that's why I think this is of consequence. It's because if you have this level of disorder where there is no order, borrowing the word, suddenly you find yourself with the least, again, of actual liberty. I always like to include this slide, the ironic role of, by the way, and I will use this acronym a fair amount, that's actually Rules of Order Newly Revised. That's the formal title of Robert's Rules of Order. Anybody know where Robert's Rules of Order was written?
England, right?
Milwaukee, Wisconsin.
Okay.
It was written right here, and as it said, it was written in Milwaukee, Wisconsin in 1876. There's the original title. He was a brigadier general in the Civil War. And he came here to Milwaukee and he got himself involved in a lot of Presbyterian church societies. I was raised in Presbyterian church societies. I now understand deeply why he needed rules of order, okay? Because they didn't always, and they still don't, always conduct themselves as well as they might. So it was never written for legislative bodies. He never wrote it to govern a Congress. He never wrote it to govern even a common council. And yet it is easily the most frequently used guide of its type anywhere in America. You know, I'm sure it runs north of 80%. So I think a lot of that helps to explain some of the idiosyncrasies and some of which we're going to touch on. But let's start with the first rule. Always remember, Robert's Rules of Order only guides and governs a body if it so chooses. There is nothing magical about Roberts. There's nothing there's no law anywhere that says you shall use Roberts unless you make that law. And we're going to talk about that too, because that can appear in a set of bylaws. But, you know, people will sometimes use Roberts as a club with which to beat one another, and I desperately want to avoid that if we can. So, what I learned on the outside, notepad in hand, when I was a journalist. One of my favorite words that I'd like to see come back to the English language is an animadversion. It's a carefully considered observation. So what I really am saying is I don't have one theme. I have some points I'd like to make and go over with you that I hope will be helpful. Animadversion number one. The vast majority of what is in Robert's Rules of Order will never, ever come up in a meeting. How many of you've seen the book? Mm-hmm. You've all seen the book. It goes to that thick. Mm-hmm. But you don't need that book that thick. You don't. You've got it. I get it, and you're going to use it. But the fact of the matter is, and I don't take that away to say it's useless. It is. It's doing so. It has a purpose. But I have brought to you, and I've shared with you out tonight, a very simple cheat sheet. I like this one. I believe this was my one from Cornell University that I've borrowed, where they go down through this hierarchy of motions. They go through I'm going to talk a little bit more about that in a bit. But the point I'm making is, don't panic. You know, when you're getting down into Robert's Rules of Order, don't worry about what you're doing. Take it from a common sense perspective, take it from a reasonability perspective, and that will serve you in the vast majority of occasions. Related to don't panic, you have people to help you. Certainly you have a wonderful executive director who has reached out and wants to direct that. You have a chairman, you have a lawyer who works with us, you have myself. I'm always willing to help. We can work through these things and make sure that they're right and make sure that they make sense and that we follow these rules. But most of them really aren't all that complicated. Number 1A. Remember this thing? Mm-hmm. Everything I needed to know I learned in kindergarten. It applies to Robert's Rules of Order. Go down that sheet I gave you tonight. Yes, I've given you homework to take home and to read your sheet and to read that basic chart of motions on the front. And ask yourself, explain. Now my son is 11. And he's been stuck listening to his dad talk about Robert's Rules of Order since he was that size, as you saw in that picture. But imagine you're trying to explain it to a 6-year-old. You can explain every single one of those motions that's going to matter to you to a 6-year-old. And when you do it that way, it loses a lot of its scary majesty. You know, everything from I move. Well, we should say that, but what are we really saying? I want to do something. Mm-hmm. I move approval. I want to do that thing. I move to amend. I move to change that thing. These are all simple concepts that we've allowed, for various reasons we'll get into, to become a little bit scarier. But keep to those principles, keep to not panicking, keep to simplicity, and it will serve you very, very well. Now, some of the stuff we're going to talk about is complicated. I won't lie, but most of it isn't. This is something I care about a lot. Work to master the rudiments of Roberts and actively discourage seeking empowerment in the minutiae of legislative process. I think you can all think of somebody I know it would be none of you, who has sought to use Roberts to thwart their foes. That's not what it's for. If you are using it as a club with which to beat one another, you are missing the point. All right, and here I get to do my little bit of heresy. When I go to parliamentarian conferences, and yes, we have these, they're a good time. We talk about these things. I'm considered a bit of a heretic, and I'm not saying you're ever going to do it, but I feel obligated to say it. I have long argued, why do we require people to second motions? Now, I know the argument. We want to make sure that somebody else wants it discussed before the body. But the problem is, when I was a reporter, the only reason I ever saw people not allowing or requiring seconds and somebody wouldn't second it, just makes somebody feel bad. You know, Mr. Smith moves, I move approval. And the chair says, any seconds? Any seconds? I guess that was a dumb idea. And we move on. It's not that big a deal most of the time. I want you to think about the times you've had to have a seconder. How many times has it ever mattered? Ever. I asked you to put it before you. This is why the Milwaukee Common Council, in its rules, in its bylaws, specifically says you don't need a second. If you've ever been to one of our council committees, if you've ever been on the floor of the Common Council, we don't take seconds. Mm-hmm. And nothing, to my knowledge, no will of the people, nothing has ever been thwarted. But it goes to that basic principle of let it be a tool of communication, of collaboration, and of open discussion, not a club. Another example. Whenever you make a motion, whatever it is, please make sure to tell the people you're making the motion to or towards, what's your or else? We want a report from John Smith's department by the 30th of June. Or what do you want? Because don't put the staff in the role, you're the deciders. You're the ones with the power and the authority and the responsibility. Tell us what you'd like. Now, this is a bit of a bigger deal with legislative bodies. You know, when I was a bill drafter when I started out, and I would say things like, and we're actually addressing this question right now with an actual piece of legislation that's come forth from Alderman Johnson about straws. You may have heard about it. That we're thinking to ban plastic straws in the city of Milwaukee. And I said to him, and he will tell you, I said, you may not offer a straw at any restaurant in the city of Milwaukee, a plastic drinking straw. And I said, or what? What do you want to have happen? You know, do you want it to be a ticket? Do you want the straw police to come crashing through the windows and take them away? You know, what is your penalty that you want? But whatever motion you make sure that your conditions are clear when you make the motion. That will assist you, it'll assist the chair, the other members of the body, and the public. Another example of one. Make sure your bodies are making the motions they're supposed to. You now have committees, or yes, you have committees. You're having committees, you're going to be enabling committees. Committees are not final deciders. That's one of the things, I have to explain this to the media all the time. A committee is an agency that you have empowered to say, we want you to talk about this thing and then let us know what you think about it. So they're going to make a recommendation back to you. They shouldn't make a motion that sounds like they're making the decision. They shouldn't make the motion that sounds like they're making the determination. They say, we recommend. Mr. Chairman, Madam Chair, I move to recommend that. And all these procedural things get gunked up a little bit when people forget what body that they're on and what the relationship is. Scam likely. And finally, one more example. Please work to ensure that motions made include directions to staff that comport with reality. I know you will do this. I have faith in you. I've worked with you for many years, and I've been privileged to do so. But what I mean by this is make sure that you have done things that fit within reasonable timelines. Make sure that you fit within reasonable expectations. And also make sure it's in their power to do. Again, this one fits more for the legislative bodies that I serve, but work with your staff in advance, even at the meeting, to break down your motions into understandable, digestible parts. That's not just to your benefit, that's to the public's benefit, so they know what you did. And it clears up a lot of confusion down the road. I've already shared my view about not using it as a tool of injury, but as a tool of building. And I feel this one very strongly to, insofar as humanly possible, encourage all chairs to explain what is going on. This is a very, very big deal for all chairs, and I don't care. And people think that because, oh, my committee is only 3 people, or my committee is only 5 or 7, it doesn't matter. It matters. And sometimes you will get so far into a discussion that you'll all be sure what's going on, but the public will have no idea. Never be afraid to take a breath, to pull back, and to have whoever made the motion restate it. I would rather have a motion made 3 times than missed once. That is why, I have an incredible, and I'm very fortunate to have a relationship with the President of the Common Council. I get teased about this. You'll see me turn around to him from time to time. And often enough, President Hamilton and I are looking at each other going, okay, he said this, right? Okay, right. Okay, good. We'll say it again. So that we understand it. There's no shame in that. There's no majesty in not making a motion clear. What did you intend? What do you want? What are the expectations? What's the or else? Break all those things down. And if necessary, say them again. This is what I learned on the inside. And by the way, I learned all those things as a reporter. I saw them all broken by bodies. I covered government. I covered every single agency of government in this county, school boards and municipal bodies, whether they be towns, cities, or villages. And I saw all of them break it at one time or another. Somebody mumble a motion, somebody not make a clear motion, somebody not give a clear direction. So I learned all that as a reporter. This is what I learned staring at my laptop. That was my old job. Looking very confused. People wondered what I was doing. I was trying to understand these things.
Can I ask you a question?
Of course. Put the picture back up.
You state that a motion should be restated.
Mm-hmm.
If I make a motion,
Mm-hmm.
and the chair would say, you heard the motion, are you ready to vote? Should he restate the motion before he asks for a vote?
Should he? I'm always going to, I'm going to say the chair should restate the motion. And I say should. That's a should. Does he have to? He does not. There's no requirement, but should he? Yes. And so that you would have a chance to say, no, Mr. Chairman, that is not what I said. And that everybody else would then have a further chance to hear it. I think that's always a wise practice. And I get it that some people think that unnecessarily lengthens meetings. I just respectfully disagree. I think that's a great point.
If a motion is made,
Mm-hmm.
the motion is stated,
Mm-hmm.
and as for the vote, and I have an unreadiness. My unreadiness is to amend the motion.
Mm-hmm.
And she has an amendment to the amendment.
Mm-hmm.
And maybe Sutter may have an amendment. How many amendments should the chair consider before calling that? Let's move on with the motion. How do you count? I'll have run into those situations. That's why I'm asking.
Well, I'm going to give you 2 separate answers. The first is all of them. The second is we'll talk about calling for the previous question at the very end, because that's a motion is often associated with debates that people feel are spiraling out of control. But let me elaborate on my first point, which is all of them. Remember when I said make sure your motion is clear and make sure it's restated? That's why, and I also said that principle about what I learned in kindergarten, take it easy, go slow, and understand, that's on that list. That's in there. And what I mean by that is you take the first motion, and that motion should be deliberated and voted and disposed of before another amendment takes the floor, unless the other person wants to amend that amendment. However, remember, and this is where I said sometimes we'll get detailed, you still have the floor. Your motion was ruled in order and is being deliberated. Someone else wanting to amend that amendment must do so very circumspectly and under certain very particular rules. And I would recommend, frankly, strongly against that. The one place where it sometimes works, and you'll see the Common Council committees do this, is you'll have made your motion, and your colleague will say, well, I didn't want 3, could I have 5? And you say, you know what, Mr. Chair, that's fine, that's 5. That's collegial, that's friendly, and that'll work. And I would never let Roberts interfere with that. If, however, there's a disagreement between the two of you, and it is principled and carried forward, your motion should be dispensed with before yours is taken up. Now, if you have a motion and you have a motion, and everybody's got a motion, one at a time, let's go through them. You know, there's no magic number at which, our allotment of amendments is done for the night. You know, we will, at the Common Council meeting coming up in early November, when we have the budget, we will probably have many dozens. Hope that.
Okay.
Sure. In most communities, Roberts does not exist in a vacuum. And this is an important point that sometimes people forget. Here in the city of Milwaukee, obviously, we have federal law, we have statute, charter, code of ordinances, procedures and rules, and you now, and I've seen the amendments, you have bylaws. And those bylaws, all these things work together. You know, these things can't, and especially, it really is a law of trumps. One of the things that I urge people, and I'll give just one very simple example, Attorney Block is responsible for open meetings. I am opposed to any set of bylaws that says that the meetings of this body shall be published in accordance to Section 19 Wisconsin statutes. Not because I want that to be violated, because, well, of course you will. That's a statute. You have no authority in a bylaw to change your obligation under a statute. You have to exist within that web of laws. And you have to show respect for those laws, and that includes Robert's Rules of Order. I'll give you some examples. Under our charter, if you go along with our basic rules, no lands may be leased, may be either sold or leased by the housing authority, quote, unless the sale or lease of these lands is first approved by the local legislative body by a vote of not less than 4/5 of the members elect. That's a mess for us. First of all, 4/5.
Right.
We almost never have that. But the other thing is members elect. That's actually a separate standard than that which we usually use. But I couldn't put into a rule, nope, these properties shall be, I would never put into a rule, I should say, this statement. That's in the statutes, and we have to obey it, right? And you know all about that. You've got 6250, and you have to obey its requirements. This is another one that I particularly like. Remember what I said, members elect? Well, look at this one. This is from our charter, 4-31. Remission of penalty or judgment requires a vote of two-thirds now, not 4/5, of the members of the council at the time of the vote. That's actually a different standard. So we have to pay attention to all those things, and we have to obey them in that way. And just in case you thought it wasn't sufficiently confusing, 3/4 of the Common Council shall be required for adoption of any resolution authorizing remediation of any environmentally contaminated property. So I've got 3 different standards, none of which is a majority, each of which is differently guided. And so you two are caught up in that same web. And by the way, just in case you thought it was only statutes and the charters that mess with us, a motion to reconsider is 8 votes if all members are present, regardless of the vote necessary to adopt the measure that is being reconsidered. That one surprised me. So we have a lot of those things too. Number 2, or I should say, this is my 5th amendment version, my second point under this category. Know your quora, your different quorums and votes. I just leave for you a very simple standard. What's the simplest way to calculate what the quorum of a given body is? half drop all fractions plus 1. Okay. So know what your quorum is. Know who has to be in a room. That isn't just an issue for Robert's Rules of Order, it's an issue for the public meetings law. It's an issue for having a legitimate meeting. But it's important to keep in your mind what are your different quora. What are your requirements to be able to meet? Also,
It's half plus 1, right?
yep. So 15 is 7.5, drop the fraction, 8.
Simple majority.
That's your quorum, that's your majority.
Four, right?
Now, also know your votes. And this is where, when you're going to go through your bylaws, I know that you folks are plotting a course where you're going to look at some of those things. Make sure you're comfortable with your voting requirements. Most of your stuff is majority vote. But if you get something that's different, know what it is. Be aware of it. Keep it in mind. It solves a lot. It prevents a lot of hard feelings. I want to relate to this. Avoid even-numbered bodies like the plagues described in Deuteronomy.
Here we are.
Look it up. They're horrible.
Here we are, 6.
I know. But you're 7 or 9, right? But avoid even-numbered bodies. I don't got to tell you why. But do it. So if you create bodies, if you don't do that to yourself. Not ever. It's just if I can. And as I say, there's our fire drill standard for quorum.
Committees.
And I throw this one in there just because you talk about needing to focus on your rules and what they say, and I know you all do, and I know the web that you've got, but this is one that we've got too from the Charter, which is derived, as it says, from the laws of 1874. No vote of the Common Council shall be reconsidered or rescinded at a special meeting unless such special meeting there be present, I like that, you can tell when that was written, there be present as large a number of aldermen, you can tell when that was written, as were present when such vote was taken. It's a special rule. That guides our quorums. Okay? So if you've got something like that, be aware of it. Now, on this one, this is a big one for me, probably less so for you, but I always want you to be aware of it. I call this, it's just a classification I have. There are 2 types of majorities in my mind. One is hard, and one is soft. What do I mean? A hard majority is one that doesn't change depending how many members are there. For example, to adopt any resolution of the Common Council or pass any ordinance, there must be 8 members present. So if 8 members show up, they all better like it. And that is why, and I'll share this out as a little side note, this is one of the points I make about abstaining. The impact of abstaining changes dramatically if you need 8 votes to pass something. Because if you need 8 votes to pass something and somebody abstains, you have voted no. Okay? You have voted no. I understand it's your right to abstain. It's a legal right, not just Robert's. But I advise you that you are voting no because you have not helped the group get to 8. Now, most of what you're going to do is what I call soft, which is to say it slides based on the number of members present at the meeting. Okay? And so therefore, in those cases, an abstention is of diminished effect because abstention is not to vote. You are not recorded as voting. You have not voted, according to Roberts. And as a consequence, let us imagine on a body of hypothetically 7 people, your quorum is half plus 1, 4. 4 members have shown up, and you only need a majority of those present and voting. So suddenly you only need 3. Something to consider. I don't know how much this comes up with you, but I deal with it all the time when I go out to other groups. Many people do not understand germaneness.
Yeah.
Everybody likes to talk about the fact, and I've heard people make it, that was not a germane motion. Mr. Chairman. I just made a motion that was not germane to my motion. And I used to hear that all the time. I heard it outside, I heard it inside. And then I actually read Robert's Rules of Order. To be germane, an amendment must in some way involve the same question that is raised by the motion to which it is applied. Skipping down. No amendment, sorry, but an amendment, note this italicized text, an amendment can be hostile to or even defeat the spirit of the original motion and still be germane. So the key point,
We should have gone into closed session. You need to go into closed session. Yes.
fortunately,
We have a motion to go into closed session.
Chair, motion to go into closed session for these purposes of training.
No fear. Immigrants are welcome here. No hate.
man, mine can't.
Immigrants are welcome here. No hate. No fear. Immigrants are welcome here. No hate. No fear.
Excuse me, can you guys quiet down? We're in the middle of training. Thank you.
That doesn't mean we don't respect what you are saying. We just have a guest who is here who's presenting to us so that we can learn to be more orderly in what we do.
Okay.
So all we ask is for this time for you to just hold it down, and then afterwards you can let loose, okay? Thank you so very much. Thank you.
Thank you.
So the piece at the bottom is, one of the things that people just don't understand is if I've made a motion that the clerk shall be purchased a chair, the motion that the clerk shall never be purchased a chair is germane. The motion that the clerk shall be purchased not one chair but 30 is germane. As long as we're talking about purchasing me furniture. So there's a difference there. And then, of course, because I was studying Robert's Rules of Order, because I was trying to become a master of these rules, I found this and was absolutely shocked. Aside from these principles, there is no single all-inclusive test for determining when a proposed amendment is germane and when it is not. I have to tell the council all the time, and I would tell you as well, it is first a ruling of the chair. If a member objects and says, Madam Chair, that, or in this case, Mr. Chair, that item is not germane, that motion was not germane, he is called upon to make a ruling. If a member objects to that ruling, he may certainly do so. But there is no law that tells you. There are these principles that say it's supposed to be about the same subject matter, that's supposed to be talking about the same thing, but ultimately it is your decision, it is reposed to your discretion. And that, and again, much the same point is enumerated here. And this is simply a point that ultimately it's reposed to the body. In most cases, it is impossible for you under Roberts to be dispositive on germaneness, no matter how much someone or someones might want you to be. All right. And my last big point, the need to end calling the question in our lifetimes. This is one of those motions that I remember I told you I don't like seconds, and why I don't like seconds? This is the one that's even worse. I like to call this the why don't you just shut up motion. Mr. Chairman, call for the question. Right? You've all heard that. I think you've probably all heard that, right? Somebody make that motion that way?
I don't know what that means.
You've never, okay. Well, right. Well, then I'll go to my next slide. Thank you for letting me know. It is properly called calling for the previous question. And here, look how powerful it is. It is not debatable. It is not amendable. And it has an unnervingly high rank in the precedence of motion. That sheet I handed you out with the table, look how high up it is. But it does require a 2/3 vote. What does it do? Well, Robert tells us right here that it comes in two forms, the qualified and the unqualified form. Remember, we had the question put, what happens if we now have 5 amendments in front of us? or we've had this long discussion, amending. If I put the motion to call for the previous question in its unqualified form, it means however many motions are on the floor, you must now, without any further debate, any further discussion, any further comment, call a series of votes on each motion, up to and including the main motion. This bit me really, really hard when I was serving as parliamentarian for the council one day, because I had 3 motions to amend in sequence, amending, and a main motion. And the motion was made in an unqualified form, which meant, and this stunned the council, that they could not discuss anything further. They just wanted to end the debate on that last item, the one that was sitting way out there at the end. They just wanted to end that one debate. But then it went, but I said, you can't. You didn't make it in you didn't make it in a qualified form. So I've got to say Amendment 1, Amendment 2, Amendment 3, and they were like on a bus with no brakes. They wanted me to stop, and I couldn't. Not under Roberts. In its qualified form, you say, Mr. Chairman, on this amendment, I wish to call for the previous question. I wish to end debate. I think we're done. And then the chair can say, on this item, rather than all the sequential stuff. So at a minimum, if you're going to make it, it should usually be made in its qualified form. And like I say, I put it out there because this actually came and got me one time. What I usually see people think this means is we're just going to stop talking and get to a debate because I think we've exhausted the conversation. I say this with respect to all those that I serve and have served over the past 20 years. I've rarely seen a time where I thought that talking for 10 more minutes wouldn't have been of benefit. You know, where I just thought that some member of the body didn't have something they wanted to add. You know, and frankly, that 10 minutes of extra time exchanged out against hard feelings or a feeling that their views weren't represented really didn't seem to be worth the trouble. But it is out there, and it is in Roberts.
What about withdrawal of that call,
Of,
the question?
if you make the motion, only the maker may withdraw it.
Okay,
Only the maker may withdraw that motion.
okay.
And they better do it quickly, because it's not debatable.
Okay, fair enough.
And it's got a very, very high priority. So, and again, some final thoughts. These are tools. These are tools for you. These charts I've provided right here, some of the notes that I've provided, I hope will be a guide to you. Whatever it is that you have questions about, please always feel free to let me know. If I need help, I'm going to seek it, and I won't apologize for seeking it. Some of the things that we do sometimes do go down rabbit holes. But again, I strongly urge patience with yourselves, patience with each other, and clarity for your own benefit and for that of the people that are watching here and at home. So with that, I thank you for your kind attention. I'm happy to answer any final questions.
Thank you, Mr. Clerk.
Let me ask, so I'll piggyback on her question. If you have what can it be done? You know, if there's a motion that need to be withdrawn, does the maker of that motion have to do that, or can a motion be made to do that?
No, it has to be made, a withdrawal would have to be made by the person making the motion.
That's right.
The remedy for a motion that you find displeasing is to defeat it.
Okay, all right.
So before anybody tries to obtain the floor, they should say, you know, Mr. Chair or whatever, and then I have to say their name and.
Yes? Yep.
And then we have to amend our rules to give it a second. So we have to do that formally, or can we just do it?
You would have to do that in your rules.
Okay.
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 I still like seconds, but fair enough.
No, like I say, you would be in the majority. I admit my
Okay, then.
I admit my rogue status, but I feel the obligation to share.
What about in the creation of like subcommittees or special committees? Is there a parliamentary procedure? I know Commissioner McKenzie previously wanted 2 committees formed, and I don't know if I can just do it on my own or.
I actually had a chance to sit down with Ms. Gibson
Yep.
and Mr. Bull this week, and we have actually gone over some revisions, draft only, to your bylaws, talking about those would all be revisions to your bylaws that would have to come back and be approved by you. I have recommended, and they have taken that recommendation, that you enumerate the bodies you want. It's whatever you want, but that you enumerate them, how many people are on them, who appoints them, what is their authority, what is not their authority, that you spell all that out. To a certain extent, we've used the Common Council procedure and rules, which are 150 plus years of blood and suffering distilled into 22 pages. And we would recommend that you sort of follow some of those basic outlines. And it's not that, it's not genius, right? But it is something that, and those will be at some point coming back to you for your review and approval.
So we can find that procedure within those revisions.
Yes? Yep. That's where you will build that.
Any other questions, Commissioners?
Not at this time.
All right, thank you.
Thank you.
Jim.
Appreciate
Very
you.
Thank you,
informative.
Jim.
All right, we'll take a